Suzanne, are you ready? Okay. Call the meeting back to order. We'll go back to Vice Chairman Johnston.
Mr. Chairman, I'm prepared to make a motion unless there's other comments or...
Seeing none, you have the floor.
Mr. Chairman, I'd make the following motion. This commission's duty, first and foremost, is to the wildlife of this state, and that includes when we look at issues of master guide licensing. I think the first duty is to the wildlife of the state, but with respect to master guide licensing, we also have an obligation to take into account the public and protection of the public and those that hire master guides in this state. Nevada Administrative Code 504.671 subsection 4 says that the department may deny an application for or revoke or suspend a guide's license for any of the following: a conviction of having violated a regulation of a federal land management agency. Mr. Wright was in fact convicted by a federal land management agency, in particular the Bureau of Land Management, for an incident that occurred on November 29th, 2016. In particular, he, his sub-guide, and his client were all cited, I believe, but Mr. Wright was in fact convicted for taking a motorized vehicle into the wilderness area. That conviction was not appealed, the fines were imposed, and the fines were paid. I would note that this conviction by a federal land management agency was not unrelated to hunting activities, but occurred during a guided hunt. And for that reason, the question is, should that conviction cause the suspension or revocation of Mr. Wright's master guide license? The department indicated that it believed it should, and made the decision to suspend the license for 2018 and not 2017 to allow Mr. Wright to complete hunts that he had booked and scheduled for this year, tried to soften the impact of the suspension, although we are all cognizant of the impact it could have on Mr. Wright next year. So this, I believe, is a de novo review, and this commission must determine whether or not this conviction should result in the revocation or suspension of Mr. Wright's master guide license. Mr. Wright asserts that it should not, because an emergency situation existed that would have allowed him, on his own initiative without contacting the BLM, to take a motorized vehicle into the wilderness area. I'm going to assume for the sake of argument that the law allowed Mr. Wright to take a motorized vehicle into the wilderness area without first contacting the BLM, that it was his decision to make under the circumstances. The fact, though, in the record we have before us does not demonstrate that such an emergency situation existed. First, we have the statement from Dana Johnson, who confronted the three individuals when they, I believe, exited the wilderness area. Nowhere in that statement from Dana Johnson is any statement by BJ, Mr. Hall, or Mr. Wright that the reason those vehicles entered the wilderness area was because of an emergency situation. Instead, and Mr. Wright confirmed, he did not speak to Mr. Johnson that day. I question if an emergency situation truly existed to justify taking the vehicles into the wilderness area. Why didn't Mr. Wright make that explanation to Mr. Johnson at the time? Mr. Johnson may have been irate, he may have been confronting them, but if there was an explanation, it should have been given. Secondly, the BLM's investigation in this matter is important in that when Mr. Wright was first contacted by Mr. Officer Culver, he denied entering the wilderness area and admitted today that he made a false statement to the BLM. It's not acceptable for a licensed master guide holding a license issued by the Department of Wildlife to provide a false statement to law enforcement in connection with an investigation that's being conducted, in connection with your licensed activities. The BLM's actions also indicate that it felt that it was a serious violation. The letter, in fact, states verbatim, the BLM takes violations of this nature very serious, imposed conditions. Therefore, the actions of the BLM were not consistent with it finding some sort of emergency situation to justify the motorized vehicles entering into the wilderness area. The conditions were to preclude Mr. Wright from commercial outfitting and guiding in the Mount Grafton wilderness area, to provide individual trip plans for every client, and all vehicles conducting business for his outfitting and guiding operation to visually mark his SRP number. And SRP, for the record, is the Special Recreation Permit. Mr. Hall's testimony also indicates that he never asked Mr. Wright or BJ to retrieve the vehicle so that he could have a ride out of the wilderness area. The record then indicates, based upon the foregoing, that an emergency situation did not exist to justify the violation of the Wilderness Act. Moreover, if emergency did exist, then the question is, why did that emergency situation arise? And in this instance, if emergency arose, if Mr. Hall was too tired to walk out or hypothermic, that situation arose because of the decisions that were made during the course of the hunt to walk into the wilderness area and to try to pack out a bull elk by 3 people in one trip in snowy, cold conditions. And that lends me to the fact that it was Mr. Wright who was responsible to make sure, as the master guide, that people got in and out of that wilderness area safely. So in that situation, if that emergency situation arose, and I don't believe it did to the extent it justified the entry of the motorized vehicle, but if it did, it further shows the situation and whether or not the suspension would be appropriate. The department considered various things that could occur. There are not special conditions that can be placed on the master guide license, and therefore decided to suspend Mr. Wright's master guide license for 2018 to allow him to complete the 2017 season. My motion is that the commission vote to suspend Mr. Wright's master guide license for 2018 based upon the foregoing facts and the provisions of the Nevada Administrative Code. This commission cannot turn a blind eye towards this type of violation. A 1-year suspension is adequate. And the fact is that we must hold master guides to a higher standard. They are the ones who are being paid by clients. They also are the ones under which sub-guides are operating. So based upon all the foregoing, I move that the commission suspend Mr. Wright's master guide license for 2018.
I'll second that for the sake of discussion. Commissioner Hubbs?
I just wanted to say, I think on the agenda it says to deny, and I know they can deny, revoke, or suspend. So are we changing that to a suspension versus a denial?
I guess I would just modify my motion to whether it's a denial of the master guide license for 2018 or a suspension, however that works administratively. I'm not sure, because I think they send in the application every year. Maybe I'm wrong, but
That's correct.
So whether it's a suspension or a denial of the 2018 application, however that works administratively, Mr. Wright should not receive his master guide license for 2018.
Is everyone clear on the motion? Questions on the motion? Seeing none, there will not be any public comment on this agenda item. And I will call for the question. All in favor, say aye.
Aye.
Opposed? Hearing none, motion passes unanimously, 7-0. That will close agenda item number 7. And I think at this point, we'll take us a lunch break until, let's go till 1:30.